Hello, thank you for watching my show. This is Christine Thompson, Baird Warner, lead agent on the CT team. And today, this week, I have an attorney with me, Steve Shaykin. Steve, thank you for joining me. Say hello.
Thank you so much for having me. Hello, everyone.
I appreciate it. So I've been working with Steve for a long, long time. So when you're listening, you got a really good agent to get information from. So Steve, we're going to talk about one element in the 7.0 contract. And I'd like you to address it to seller perspective as well as buyer perspective. It's a big one that's been going on because, you know, we have multiple offers going on and buyers are stepping in there saying, hey, to make my offer stronger, I will do as is. Or sellers are demanding that of buyers since they kind of have the upper hand with a multiple offer situation. And a lot of buyers and sometimes sellers misunderstand what exactly that means when they're agreeing to as is and the 7.0 contract that we use in our area. So I'm going to kind of give the show to you and have you talk about the ins and outs of as is and what that means to a buyer and seller.
Thank you again for the opportunity. You're right. As is probably the most misunderstood term. Both buyers and sellers believe that if they agree to buy it as is, then they're stuck with whatever the condition of the property is. And technically, legally, as is means the seller is making no promises or representations about the property's condition. It's up to the buyer to determine what they are or are not getting. And the as is paragraph, which is an optional paragraph, which, like you said, every seller wants and buyers are going to have to agree to in this market, allows for a separate inspection. So there is a separate provision in the contract, as you know, for inspections, but when the as-is clause is used, that provision about inspections is omitted and the language of the as-is paragraph is in play, and it allows for the buyer to do an inspection to determine what they are getting in its as-is condition. And if they don't like it, or if they find things that they didn't expect, they're allowed to terminate the contract and, you know, get their down payment, their earnest money back. So that process does give buyers some negotiation room to say, well, I did my inspection, I bought it as is, I didn't expect to find ABC, and I did. So would you consider a credit or something of that nature? And all the sellers, they get a little upset about the fact that how can they ask for this? They bought it as is.
Right,
Meaning,
exactly.
like, they're stuck for it. They've got to buy it no matter what. And that isn't exactly how it works. So
is that because the home inspection paragraph in the contract still is valid? I mean, the as-is doesn't annihilate that right, because that now we're talking about waiving inspection, right?
the technical language of the inspection clause, which I want to say is paragraph 12, is not in effect if the as-is paragraph, which is one of the optional paragraphs like 34, is in play. But in paragraph 34, it provides almost identical language to what paragraph 12 says, that the buyer has the right to inspect and that, you know, minimal minor routine matters don't count, but any other matters do, and that the buyer has the right to cancel. So being that they have that right to cancel, it gives them at least the opportunity to discuss it. But, you know, buyers, I counsel buyers to be careful. If there's something significant, of course, but, you know, with your minor routine type inspection
type
item,
stuff,
you know, you don't want to play with that in an as-is deal. And the buyer should understand that going in. And the sellers, if there's something significant, you know, a major plumbing problem, an electrical issue, something significant with the foundation that sometimes the sellers aren't even aware of,
right?
Then, you know, the buyers have the right. They're not stuck without having a professional go in and give them the nice, warm, fuzzy feeling that, yeah, it was inspected and it came out exactly as you expected it to.
Right. So what you're saying is, let's say the buyer goes in there with an inspector and surprises come up. They're kind of big ticket items. The buyer doesn't have to automatically say, oh, I don't like that situation. I guess I can't buy it. I'm going to have to back out. They have the option to go back to the seller and say, hate to do this to you, but we discovered some big ticket items here. We'd still love to have the property, but we're going to have to come back to you on these 2-3 issues that were really big issues and say, are you willing to work with us on this? So that way we can keep the contract moving forward.
You know, the buzzword of the day is mold. So let's say they find mold, which is another topic for a whole nother show. But, you know, then they can negotiate. They certainly have the right to negotiate. The seller can say, no, you bought it as is, and I'm not doing anything. And then the buyer can decide, is the deal worth it to them to proceed and deal with it on their own? Or is it not? And then they can cancel. And in multiple offer situations, sellers are usually not so worried about a buyer canceling because they had other significant offers that they had to choose from anyway.
Right. Yeah.
So,
yeah. The two buzzwords that I find that I warn my buyers and I also warn my sellers about are, sorry about that, are mold and radon. But we're going to say mold and radon for another show because that's a whole, those are two other
absolutely two shows. Because one could be on mold and one could be on radon.
Yeah, there's, you know, and you know, if you're watching this show, and Steve, you can attest to this, is there's the written language in the contract, but there's so much hidden in that legal contract that you need to understand. And the only way you're going to really understand what's all the hidden finesses in this contract, work with an agent, have an attorney, because you're not going to see all those hidden little loopholes and negotiations built into this 7.0 14-page, 13-page contract. It's probably going to be 14 soon enough. Would you agree with that, Steve?
What's interesting is that if you took that contract and typed it out in normal size type and font, it would come out to be like 32 pages.
Oh, I know.
Because it's printed on a smaller.
Oh, and yes, jammed in there. Yeah.
And I couldn't agree with what you said earlier more. That is exactly right. There's a lot of logistics and procedures that fit in with the technical language of the contract. And that's the finesse that someone like you, who has all the experience you have, and myself, are able to negotiate on behalf of the client.
Yeah. You know, I was just talking to a client on the phone, and he was asking, are things going to just go to robot where it's like, you don't need anybody involved. You just do the contract. You get your own inspector, you go into the house, you know, there's a key there to help yourself in. And I said, no, because a consumer reading a 7.0 contract, they're not going to see all of the hidden information and negotiations built into these contracts. There's no way. You need someone that can explain it all to you. It's just too complicated, you know, so you need someone that's experienced. And I learned that when I first started in the business 22 years ago. And my mom, being a realtor, I remember calling her for advice, and she would point that out. And I'm like, oh, don't read just the lines in the contract. There's a lot behind it.
Every buyer's needs are different. Every seller's needs are different.
Yeah.
And the contract doesn't change, but those things around it change, which means you handle the issues differently in different situations.
For sure. So we're going to hit a lot more topics. Steve, I'm going to have you coming on live every other week. The other weeks I'll have my lender on there because there's so many elements to purchasing and selling a home. I really appreciate your time. If people have more questions and they want to reach out to you, what's the best way they can reach you, Steve?
My office number is 847-749-3663. My email is pretty easy. It's my name, Steve@Shaykin, SHAYKIN.com.
Awesome.
And my cell is 224-595-1216. Everybody gets my cell phone. I'm reachable pretty much 24/7.
Which is unheard of attorneys doing that. Steve, you're the best. And I've got my little raffle text code here because Steve, you're going to offer one-time offer, a raffle. And what
I
was it
am.
that you were going to offer?
I am prepared to take $150 off a closing fee or $150 towards a consultation on an estate plan.
Awesome. So everybody start texting the word raffle to 630-931-0045. You want to get that bonus with Steve. Steve, thanks for your time. I appreciate it. And we'll see you in 2 weeks.
Everyone have a great weekend.
Thanks, Steve. Bye-bye.
Bye.
Bye.